police DPP mu article y'ekikumi alina obuvunanyizibwa okulaba nti investigation zikolebwa mu bwenkanya ate mu bwesimbu. Alina obuyinza mu article y'ekikumi ya ssemateeka okulagira police okuinvestigatinga omusango mu bwenkanya mu bwesimbu. Kati obuzibu bwe tusanze nti bano bali ku kesi nti yakuma mu bantu omuliro era kyovula bagaseeko ne bana abantu abirimu naye tebafuddeeyo ku investigatinga kesi ya mada ey'okutta abantu abattibwa ewa Honorable Muwanga Kivumbi ewaka. Abantu 10 baafa wano mu kyaji kyetu bo bagamba abantu 7 naye ne baba 7 tebafuddeeyo kugamba nti battibwa gundi ne gundi. Era abantu abatta aba poliisi oba amagye agatta abantu abo tebali mu kaguli, tebabavunaanyizibwako misango. Tutaddewo akazito DPP annyonnyole oba ddala waliyo fayiro gye batambuza gye banoonyerezaako ku abo bennyini abaapuulinga trigger ne batta abantu. DPP agaanye. Era nga Muwanga Kivumbi yali alikodinga statement ku police yabagamba batta abantu 10 ewaka ewange bagenda okubi-investigatinga. Kati ekyo twagala kooti etunulemu nga tetunnabagenda mu maaso. Lwaki tebaagala kunoonyereza ku b'amagye ku bapoliisi abatta abantu ewaka wa Muwanga Kivumbi abali abantu 10 yadde bo bagamba abantu 7. Ekyo tugenda kiteekako nnyo amaanyi.
Tukwaniriza ku Kabyanzo Media.
Even if it is taken as a fact that they were 7, who killed the 7? That is the issue. Who killed them? And why are they not being prosecuted?
Worship have received information from their children. His brother Haji Musa reported that the prosecution has been part of the lopsided investigation by way of allegation from my colleague, the assistant DPP. We now know that Madam Rachel Bihole, representing the Director of Public Prosecution, participated in the proceedings at Chila Police Station, where the accused was being forced, representing the Director of Public Prosecution, participated in the proceedings at Chila Police Station, where the accused was being forced to stick to a script dictated by the state. We now know that the Director of Public Prosecution instead of even undertaking to investigate a complaint regarding lopsided investigation, is owning up but has yielded the floor without telling court.
Tukwaniriza ku Kabyanzo Media.
Because he insisted on writing a statement based on what he knew and observed. While at Chira Police Station, everyone was required to record a statement. And in the presence His lawyer comes to my adversary. Voluntarily submitted to the process. And started narrating the story as it unfolded. On the 15th day of January. And when he reached a segment where the police and the military murdered 10 people. In his house. The person, the officer recording the statement declined to continue with the statement. He insisted that the accused person would proceed with the statement recording provided matters to do with the murder in cold blood are omitted. In simple terms, that the detectives who were not at the scene would dictate the statement to be recorded. Impartiality in criminal prosecutions that is impartiality in criminal prosecutions at all stages, including investigations, is cardinal and non-assailable. As an integral part of the prosecution. The partial and lopsided criminal investigation, is an affront.
You say the partial?
Partial and lopsided criminal investigation is an affront to due process. It must not be condoned. The decision by the prosecuting authority, therefore, must be hinged on an impartial and a fair process. Lest it be treated as a nullity. The signature, therefore, of the prosecuting authority that is the officer preferring the judge who is not known anyway, and we shall reach that stage at some point. And the consent to the judge by Mr. Lino Anguzu, the Director of the Prosecution, are premised on a lopsided investigation. That were reached without hearing the accused's version into the case. Murder in cold blood by state operatives is being covered. And therefore this prosecution is premised on that background. It is therefore not surprising that it culminated into the smuggling of the accused person into court without informing his lawyers and without notifying his next of kin. Prayers. One, without going into trial therefore, and having abused the constitutional provisions, we would invite court to terminate the proceeding. Discharge the accused person. But in the microscopic event that court is not inclined to direct one that the team of detectives that conducted that operation be directed to recuse, and the new and impartial team be put in place to do a thorough investigation, including investigating the murder. That a director will be issued?
Yes,
Related as a team of detectives.
of impartial detectives conduct a thorough and fair investigation including an interrogation of the murder in cold blood. Of the persons mentioned here and others who are not mentioned. And that the murderers themselves be brought to book. The rest of our submission will be without serious requirements.
Issue the submission of November 3rd. Your Worship, put emphasis on the issue of the roadside investigation. Your Worship, is fundamental. My Lord, Your Worship, I refer you to Article 120, Clause 5 of the Constitution, which provides that in exercising his or her powers under this Act, that is the DPI, the Director of Public Prosecutions shall have regard to the public interest, the interests of the administration of justice, and the need to prevent abuse of legal process. These are key tenets regarding management of our criminal justice system and administration of justice. Your Worship, Clause 3 of the same Article 120 provides as follows. The functions of the Director of Public Prosecutions are the following. Third, to direct the police to investigate any information of a criminal nature and report to him or her expeditiously. I'm going to the rest. And Lord, the accused persons have the right to know at this stage from the prosecution here whether the DPP whom they represent in this case invoked this particular provision of the Constitution to direct police to investigate that particular matter of murder, they call it murder. 10 people at the home of the government. The security intelligence to the people's manipulation. The Director of Public Prosecution has the powers to intervene at the police to investigate any information of criminal nature and report to him or her expectations. My Lord, we are managing pre-trial processes before them, and they are critical. They are critical to the administration of justice. So one of the pre-trial rights is the right to information regarding management of the matters. So we seek to know whether the DPP directed the police to investigate that matter in accordance with this statute. And we will not be denying it. Two, in addition to the prayers made by my friend, Your Worship, and without prejudice to the prayer to terminate the proceeding, which is within your power, and also the prayer to made to direct the independent investigation, I would wish to add one in the alternative, Your Worship. Your Worship, it's in clause 7 of the Human Rights Enforcement Act, Cap 12. Specifically, yes, sub-rule 2. Reference of human rights matters by subordinate courts. Where in any proceedings in a subordinate court, any question arises as violation of fundamental rights of freedom, the magistrate shall refer the question for determination by the High Court. And where a human rights matter arises in any proceedings, this is clause 2, that is clause 1. And where a human rights matter arises in any proceedings before the magistrate court, the magistrate court shall immediately stay the proceedings in the main matter and first determine the human rights issue raised. 3. The magistrate presiding over proceedings referred to in subsection 1 may stay the proceedings until the reference is determined, and in case of a criminal trial, grant bail to the accused person. This may sound alien, given that this matter is triable by the High Court and the right to that fact. And by bail may be presumed to be below the preserve of the High Court under present circumstances. But my Lord, there is this window which was created by Parliament, by an act of Parliament. And this is the law we are setting before you, my Lord. In the alternative to the prayers made by the Honorable Madam Secretary. Finally, my Lord, Your Worship, and according to 8, my Lord, Your Worship, Argument 8 is about the right of fair hearing, which starts from the time one is arrested. And Your Worship, here in clause 3 of Article 28. Person shall immediately be informed in the language he understands of the nature of the offense. At that time upon arrest, which was not done as submitted on my copy. Clause 3G provides that the person shall be afforded the facilities C, be given adequate time and the facilities for the preparation of his or her defense. Your Worship, preparation of the defense starts at the time we are given instruction under the time of the committee. It starts at the time of instruction. And it's at this stage that the accused person must be afforded all the facilities required, including sufficient information regarding the investigations being conducted. The line that is being taken on to this matter is like, we are coming today, they are adding another 4. Just come before court, and then you are ambushed with an amendment to the charge sheet. And you've seen how we struggle, Your Worship, to manage this. Uganda Law Society has some representatives. Marian Friend had to interact with the accused persons. But they knew the matter was coming up to them. They had the amended charge sheet, and they could not share it with us in time. So we are saying, my Lord, as we are managing the pre-trial processes, all the information in possession of the state regarding management of the pre-trial processes should be available to us in time, so that we are able to prepare adequately, not to be ambushed. So that we have time also to interact with the accused, because can you imagine what we are doing today? Representing the 24 without even getting their bank account, getting information from them, how they have been treated in prison and so on. We didn't have that time. They just ambushed here. So trial by ambush is evident to our constitution, and my Lord should not be committed. Your Worship should be committed. We do so.
Your Worship, the defense have raised unfounded allegations, allegations of violation of human rights, allegations of impartiality of the investigations. All these are just mere hearsay allegations without any evidence presented to prove the same. The investigations in this team have been conducted by a team, has been conducted in teams of investigators and teams of prosecution. We have handled the matter by way of prosecution-guided investigations. We have ensured the integrity of the investigations. And we have thoroughly reviewed the evidence and come up with appropriate charges against these persons in the circumstances. My Lord, it's just mere allegations to say that our investigations are impartial or lopsided. Our investigations are impartial and have maintained the integrity or whatever police has investigated. Needless to say, Your Honor, investigations in this matter are still ongoing. Most of the issues raised by the defense will certainly be handled as we continue the investigation. The role of this court right now is limited to communicating the charges to accused persons and to mention of it. Yes. Counsel knows the procedure for termination of criminal proceedings. And also the competent court to do the same. This court cannot therefore make a determination to terminate charges on unfounded allegations, and besides, it does not have the jurisdiction to do that. We have endeavored to ensure that we make the necessary disclosures to the defense right from the onset of this case. And we have a very clear timeline disclosure. That will certainly address some of the issues that have been raised by the defense.
Tukwaniriza ku Kabyanzo Media.
Okay. We now know, as the defense, that the prosecution has been part of the lopsided investigation. By way of admission from my colleague, the Assistant DPP, we now know Madam Rachel Piholi, representing the Director of Public Prosecution, participated in the proceedings at the police station, where the accused was being forced to stick to a script dictated by the state. We now know that the Director of Public Prosecution instead of even undertaking to investigate a complaint regarding lopsided investigation, is owning up but has yielded the floor without telling court why they do not have a statement from the accused person, who is now incarcerated in Italia, and the state says even that one will be handled. In other words, the police detectives will hunt him down in Italy and continue investigating him. A job they did not do while in police custody. The denial of the accused person, the person to know the charges against him, has not been responded to. There is no rebuttal onto that. There is no rebuttal onto a complaint that the accused was smuggled and brought to court without informing his next of kin and lawyers, even when he had a lawyer at police in jail. The murder in cold blood by the state at the accused's house with the bullets owned, controlled, and released by soldiers in military uniform has also not been responded to. Maybe 10 lives are not important enough for the big state to respond to. The state, having considered that the matters we have raised will be handled, I treat that as a concession that they concede to the prayer of directing an impartial investigation, including investigating the murder of those innocent Ugandans. I agree with counsel for the state that we, counsel for the defense, know the procedure. Yes, we know the procedure. And we have adopted that procedure by raising it. Indeed, the Human Rights Enforcement Act does not require us to wait and go anywhere else. The competent court is this very court. Jurisdiction in the trial of terrorism, we agree, is the High Court. But the jurisdiction to investigate human rights violations rests with this honorable court. The disclosures referred to, where the state is playing only relate to the amended charge sheet that was thrown at us upon prayer in court. Not the charge sheet before, not the fact that the accused will be arraigned before court on a particular date in a particular place. When Ms. Bihole and the lopsided police officers concluded their process, lopsided process at Chira, they simply drove here without informing anyone. So the disclosure she's talking about is partial and not in good faith. the refusal to give the required information, and indeed treat it as unfounded. Instead of investigating it, it is also taken to be in bad faith, which is not consistent with best practices of decent professionals. I therefore reiterate our earlier prayers. Your worship, I invite you to exercise the duty imposed onto this by the Constitution and the Human Rights Enforcement, and direct us pray. So pray.
About the omission to investigate the matter at the house of accused number 1. What is the information about it?
When the accused first raised the matter, the question of murder of people at his house, the police told him to abandon that line and answer questions they asked him. And it is upon that stage that the police decided to terminate his statement recording. A clear indication that they did not want to hear about it, and to that they wanted to dictate the kind of statement from him. To date, he has no statement. I can challenge the state to produce this certificate. In fact, the investigation, the line of investigation at that point was that they were investigating his inside the violence and not the murder of those innocent Ugandans. In other words, inciting violence is more important to them than the murder. True. Probably it would have been important, because if he incited the military to kill, that is a criminal offense. But I thought it's a bigger offense that the military succumbed to the incitement and killed.
Maybe reference to Article 120, where the DTP is enjoining to command the police to investigate information relating to criminal offences. And they are here, they are starting DPPs, they have circumvented that issue.
The question is, for you and the neighbor, who reported the murder to police?
The accused person, in the process of recording statement, says the murder. They say, don't talk about the murder.
I thought it would start with a report. It is a specific statement being made about the murder.
And to report the murder to the murderer, I need to be guided. Because his accusation was that the police came to my house and murdered. Now that the state has not invited me, but arrested me, and is asking about the events in Muwanga, I am telling you that where you were not, your police officers and the military officers murdered people. That's number one. Number two, for information, you even asked the question, who is the complainer? They said the DPC of Muwanga said actually that DPC commanded a raid on my house and murdered. He said we will not. Now, the point raised by Mr. Tejas is that once the DPP has a file, he has a duty to command the police to investigate this. Now we've learned from court that actually the DPP or the prosecution was part of the investigation that refused to investigate the murder.
Is my
But before they come in, I'm sorry, before they come in. Because even if you don't talk about the information, you furnish to the police. There is preliminary evidence here in the charge sheet. There is preliminary information that 7 people died. Now let's not talk about the numbers. 10 settled. The fact is,
They were murdered.
they were murders. And the right murder is not being investigated. And this is what we are asking, whether, okay, even if it is taken as a fact that there were 7, who killed the 7? That is the issue. Who killed them? And why are they not being prosecuted?
Worship, I've received information from Yaju. His brother had Musa reported the murder which he the police station. And the DPP is running away from investigating it, even in court here.
I'm not putting you on the but I'm trying to get the clarification of the matter.
First of all, I think counsel needs to understand what a prosecution-led investigation is. It does not mean that the prosecution has eroded the powers of police to investigate a criminal matter. We are supporting police at the onset of an investigation. We are directing them to conduct these criminal investigations. So it is not right for counsel to come and say that police or the DPP do not bother to direct the investigations into the murder of 10 or so persons that were killed. We have conducted an investigation into the murder allegations, and as a result of that, that's why we have some of these charges in court. And investigations in the matter are still ongoing. So it is not proper for court to be misled that we have had a one-sided investigations. No. Every murder that is unlawful is investigated by the state, and that's what we are doing, and that's what we have done, and that's what we continue to do.
So if the brother of at least the number 1 reported to the police the murder of 10 people at the house, okay, is that matter being investigated?
No, that is the matter that we are investigating. And I think the unfounded allegations by the defense need to be put here.
Or investigated?
No. You're making assumptions. Here's the evidence that police, that the DPP have not done investigations in the matter. And yet we have. That needs to be put here on the board. Your Worship, there's also no evidence that that A1 was not interviewed. He was.
You have his statement.
We have his statement, sir. At the right time, we shall disclose.
Your Honor, for the record, I was at police at Chila, where everyone was brought to the draft arrest. And while at police, there was an attempt to force him to make a statement in line with what the police preferred. And we took issue with that line. And at that point, because what, Your Honor, I did ask the police what they were investigating. And they said, we are investigating incitement and malicious damage. Those were the 2 cases they were investigating. And that relates to the issue of ambush that has been talked about. So they said they were investigating incitement and malicious damage. Now, when A1 Honorable Muwanga Kivumbi sought to state that there were murders in his home, imagine people taking a statement, objecting. Who was supposed to be taking a statement, they objected. Said, but this is my statement. Let me say what I saw and what I know. They objected. And when he insisted, and we insisted on that information, going on record, they say we will not proceed, and they immediately, of course, they were very angry and very personal. They just closed the file. So what they are purporting, what the state is purporting, that there is a statement, is actually no statement at all. There is no statement talking about terrorism. And I want we will bring it, we will ask them to produce any statement where A1 is being led to talk about issues related to terrorism. They have no statement at all. And that is the travesty. But also too, Your Honor, relates to the issue of investigation still ongoing. Your Honor, I think the state and court should not condone this practice of arrests being made hastily and investigations are made later. It is creating the travesty of the criminal justice system. People are being on remand for years, Your Honor. 5 years, 9 years. We have even a case, Your Honor, of a person who has been on remand for 30 years. 30 years. Because of this act of rushing to make arrests, then investigations are made later. I think court should never condone the practice of arresting people, remanding them, and then carrying out investigations. The right thing that prosecution should be doing, Your Honor, is to thoroughly investigate, so that by the time people are brought in court, they are asking for hearing dates, not asking for adjournment to carry out more investigations.
I think I should set a date to do a ruling in the matter there that have been raised. When the matter comes up on the 17th.
First, we are not agreed on the 17th, because the 17th is what they asked for. But we want to do whether today or tomorrow, the other day.
I think it should be on the 17th. So in the meantime, we are still for the remand.
He has maintained the 17th.
It is more convenient to you.
I see hands from the persons that I have interviewed, because as I was beginning to talk to them, then we were called. I see their hands and not one.
They want to address me direct, or they would rather give to you?
Where will they find me? Because we have been entitled.
Why wouldn't they allow you? They would have all the day allow you to
do not know someone might be about to die, and they put their hands up.
What do you want to do? What about you? You are all talking about baby? No, now baby is now out of the question. Because the matter has been put out of, originally you had been charged for an available matter, but now it has been put out of our hands. It's supposed to be a high court matter.
So,
if you are not ready for bail, you do it in the right court.
Maybe I would also ask their lawyer, because the original charge sheet was this. So what happens to their charge sheet of incitement?
Poor connection.
On the same facts, same everything, they have two separate charges before two different magistrates judicial officers. Anyway, it's okay. It's okay. They are not
two different criminal cases.
No, it's okay. They are not embarrassed because they can't be embarrassed.
Papa.